Over the weekend, the Electoral Court finally released its reasons for its ruling that former President Jacob Zuma can be a candidate for Parliament from Umkhonto, despite the Constitution saying that someone who has been sentenced to more than 12 months in prison in the last 5 years is not eligible. The 3 judges and 2 professors who made up the court all agreed Zuma can stand. The main reason for this, they say, was that Zuma was sentenced to 15 months in prison 3 years ago by the Constitutional Court and thus could not appeal the sentence. But the court actually issued 3 separate sets of reasons for this decision. There are also important findings in these rulings about whether there is any legal difference or distinction between being eligible to be a member of Parliament and being eligible to be a candidate for Parliament. The Constitutional Court has already indicated it will hear an appeal against this ruling by the Electoral Court, by the Electoral Commission, The Electoral Commission says it needs clarity on this issue. Benedict Phiri is the founder and managing director of IusPrudentia, a specialist counsel, and then Michael Atkins is an independent election consultant. Gentlemen, good afternoon to you, and thank you for your time. Benedict, if I may start with you, what is this judgment saying about the issue of sentence? Why does the court not believe Zuma was sentenced in a way that disqualifies him from standing to be a member of Parliament?
Yeah, it's a big interpretation, Stephen, in respect of Section 47(1) of the Constitution. Essentially, what the court came to was that because the Constitutional Court imposed that sentence and conviction on Mr. Zuma, his conviction and sentence wasn't the subject of an appeal. So Section 47(1) says that you will be disqualified if you have been convicted and sentenced for a period of more than 12 months in prison. Mr. Zuma was 15 months, but provided that it doesn't have an option of a fine, and that period of disqualification only starts to run after you have actually exhausted all your avenues for an appeal, or the time for an appeal has actually run its course. So in Mr. Zuma's case, the court found that he actually didn't have an appeal, and for that reason, he couldn't be hit by the disqualification because you could not technically come to the conclusion that he'd exhausted his avenue for appeal or actually run out of the time for launching that appeal. So in a nutshell, that's why the court finds that he can actually be a candidate for the National Assembly in this particular instance.
So, Benedict, if I were the Electoral Commission and I was appealing this, one of the arguments I suppose you could make would be the sentence in this case was imposed by the Constitutional Court. If the sentence had been imposed by a High Court, and in fact the Zondo Commission could have gone to a High Court on this, but if the sentence had been imposed by a High Court, then he would not be able to stand, which in other words would mean then that a sentence from a High Court would have more consequence, more power, than a sentence from a Constitutional Court.
It's an odd interpretation that the court has reached here, Stephen. I agree with you. It's not entirely an unjustified interpretation because the wording of the section invites that interpretation. But yes, if I was, as the IEC will be arguing, is that he was sentenced by the highest court in the land. And because of that, he doesn't have a right of appeal. And over and above that, we shouldn't forget that he actually tried a rescission application in respect of that contempt conviction, and in which case the court, in fact, kept open the question for future litigants whether anybody could approach the court to rescind any one of its judgments. So that particular, point in law is actually still open. And when you see it in hindsight, you can see that it's probably good law in this particular instance, because it would make no sense that you would actually be in a more beneficial situation if the matter, if you are convicted by the High Court as opposed to the Constitutional Court. One of the examples I made this morning, Stephen, is if, for instance, I sue you for contempt of court in the High Court, and you beat me in the High Court and you beat me in the SCA, but then the Constitutional Court eventually ends up being the one that sentences and convicts you. So in that particular instance, you wouldn't have a right of appeal, even though the matter had gone from the High Court all the way to the Constitutional Court. And certainly in the rationale and the reasoning of the court, that kind of eventuality is not contemplated. And I'd like to see that fleshed out, because then that also has to hang together in the context of this decision.
Michael Atkins, how do you feel about this ruling? I mean, I think most people felt that the Constitution was pretty clear in terms of what disqualifies someone from actually becoming an MP. And now suddenly it's become quite complicated around which court did the sentencing.
You know, from an electoral point of view, I see the reasons for the order as really good news, because the legal people can go off and have their debates and discuss the matter, and it can be thrashed out in the Constitutional Court. And it does seem fitting to me that the Con Court rules on the interpretation of the Constitution. But from an electoral point of view, those reasons do not disturb the election. There is nothing that stops the preparations for the election going ahead. There is nothing that brings into question the IEC's role in terms of Section 30 of the Electoral Act and excluding candidates. And there is no, if I can be blunt, there is no slur cast on Ms. Janet Love, which was one of the claims that she was biased. The court did not find any bias. So in a sense, from an electoral point of view, we're actually good to go, and there isn't any ground for contention around this issue.
So, Michael, does it matter then? The Constitutional Court, is going to hear this, I think, on the 10th of May. The elections are on the 19th of May. I'm going to come to Benedict in a moment about a technical legal question around this. But what happens if the Constitutional Court doesn't make a decision by the elections, or even 14 days after the elections when the National Assembly has to sit?
Okay, legally, very little happens, except obviously you raise a good question of would it be possible for Mr. Zuma to be sworn in as an MP. So let's hope that it is resolved before that point. It doesn't halt the conduct of the election. I would argue that before voting day, it would be important to know, so that voters know when they are casting their ballot whether Mr. Zuma can go to the National Assembly or not. That is a broader and a more philosophical point, but in Section 19 of the Constitution, we have the right to make political choices, and those political choices must be well-informed political choices. So I would argue on a philosophical point of view, it is better to know before the election whether Mr. Zuma can become a member of parliament, but the sky doesn't fall in if we don't know.
Benedict, here's a technical question. You mentioned the point that there's a lot around the law around sentencing that will come from this. And the thing with the Constitutional Court decisions is everything they say sets a precedent. So they've got to be very careful. And that worries me that actually this might be quite a long time before we get a judgment from the Constitutional Court, because there are many more issues that come out of it than the question of around Zuma. Issues around sentencing come out of it too.
Stephen, to be honest, I don't think this is so much a question about sentencing as possibly the question of the legal effect of a remission of sentence. Because, when I read that judgment, the judges, except for Judge Bodiba, are quite clear that, the sentence is the factual sentence that was imposed by the court. So in this case, 15 months. And the remission did not have an effect on disturbing that factual position. Yes, it had an effect on releasing Mr. Zuma earlier than the 15 months, but, from a factual perspective, he was convicted and sentenced for a crime for a period in excess of 12 months. So I think the court will be clear on that. What I am looking forward to the court clarifying is what is the effect of this remission, because that's really where the disagreement comes from the judges. One of the judges says the effect of the remission is to reduce the sentence to 3 months, and that it isn't within the president's powers to actually do that. And how the majority of the judges sort of dealt with that was to say, well, this wasn't a special remission for Mr. Zuma. Had he actually applied to the president, then the president might have applied his mind to that very fact. But because it was a general remission for all other prisoners, you can't say that the fact of his conviction for 15 months was disturbed. So I don't think that's what will come out of here, Stephen, but it is an important conversation insofar as determining what is the effect of these remissions and pardons. We've got a few matters already where we know the effect of the pardon, but it is an important matter given, the fact that these instruments are used as a policy instrument by presidents to deal with many issues within the prison system.
And Benedict, this issue of a possible distinction between qualifying to be a member of Parliament and qualifying to stand as a candidate for Parliament. Is there now finality on that? If I remember correctly, from my reading of the judgment, there's no distinction between those two things.
Yes, I think the court, all the judges were were unanimous on the point that the IEC actually has the power to adjudicate an objection for somebody running for Parliament, and that isn't something that has to sit with Parliament. I think that was quite clear from the judges that they interpret the IEC Act together with the Constitution as giving the IEC the power to actually adjudicate an objection for somebody's candidature to the National Assembly. I expect the Constitutional Court to also uphold that principle.
Michael, this is quite important in a way, isn't it? Because it's re-establishing or establishing legally the power that the Electoral Commission here has to decide who goes to Parliament. Michael, if it had gone the other way and Parliament had to decide who goes to Parliament, I wouldn't like to predict what would have happened.
Yes, it would have been absurd, and I agree. Section 30 of the Electoral Act, which is the IEC being able to decide on objections and remove or keep people on the lists, that would have had no effect if you had the distinction between being a candidate and going to Parliament. There would have been no purpose to even have that section in the Electoral Act. So yes, I certainly look forward to reinforcing that point, and that the IEC will be able to proceed with their role in future with full confidence and not to have further challenges to that authority in future elections.
All of this is important, Michael, because, a lot of mud's already being thrown at the Electoral Commission. It's coming from different sides, as you would expect in a contested election. But the rulings actually matter. If judges said the Electoral Commission got something dramatically wrong, that would hurt the legitimacy of the Electoral Commission. As you say, that hasn't happened in this case. That's important.
That's correct. Any criticism or any aspersions cast on the Electoral Commission must always be motivated by sound reasoning or clear evidence. And a lot of comments flying around are the exact opposite. They're subjective, and to my mind, Friday's judgment slams the door on anything arising from the current situation, that it doesn't leave that open. And even the decision to appeal the Electoral Court ruling is itself not impugned because the court is willing to hear it. They've set down a date. So nobody can point a finger and say that the IEC has acted incorrectly in this matter.
Benedict, so we expect the appeal. We expect it to be heard in a couple of weeks. Any predictions on which way it's going to go?
Stephen, at this point, I think this one has been a little bit unpredictable. I do expect, the Constitutional Court, obviously they're going to have to weigh in on the question of whether Mr. Zuma was qualified by virtue of the point around him, sorry, Stephen, I'm just catching my breath there, his conviction and sentence basically not coming into effect. I think that's an important point for the Constitutional Court to qualify, and I expect the Constitutional Court will say that that disqualification is in place for Mr. Zuma.
Benedict Phiri, thank you, founder and managing director at IusPrudentia Specialist Counsel, and Michael Atkins, independent elections analyst. I really appreciate the time.